Good morning and welcome to WGN-TV Political Report. I'm Paul Lisnek. We begin this morning with a topic we talk about often on this show, violence in Chicago. For nearly a year, Mayor Lightfoot and Police Superintendent Brown have been pointing the finger at the court system for allowing violent criminals to stay on city streets. Well, this week, I sat down with Cook County Circuit Court Chief Judge Tim Evans to talk about those accusations and his approach to healing a broken city. Judge, thanks for being with me. I appreciate your time. You emphasize the importance of the due process of law, and the system's got to do its thing. But look, you're a former alderman, you understand politics. How do you balance the politics and address the politics of the violence that's going on in the city right now with the fact that you understand there's a legal process?
Well, it's not easy. You're right. Most people don't understand the due process that I'm talking about, even though it's covered in our Declaration of Independence by Thomas Jefferson. It's covered in the Fifth Amendment. It's emphasized in the Sixth Amendment. It's covered in the 14th Amendment. Most people don't know about that. And that's the beauty of having an opportunity to talk to the public through people like you, Paul, who give me a chance to explain that it's not just the charge. The evidence has to be there, and we have to presume somebody to be innocent. And that presumption has to be overcome before they can be found guilty beyond a reasonable doubt, and also before somebody can decide whether they should lose their liberty even before there's a trial. And when you talk to people about that, they say, well, wait a minute, would the police have arrested this person if they didn't think he was guilty? And here's the state's attorney has prosecuted the person. Don't you think that means that person probably did it? I have to say no. We have to see the evidence. What is the evidence? And that's where that due process issue comes in. Yes, I know the public has to decide who to believe. I realize that. And we all have to face the consequences if they don't believe us. I realize that too. But I think we have to tell them the truth, and that's the truth.
So part of this, the public battle, of course, involves the mayor, Kim Foxx, yourself. That's kind of the three pieces of the stool here. And isn't it true that with regard to who's going to get out or who's going to get electronic monitoring, the state's attorney plays a key role in that? We don't really hear about that, do we?
Absolutely, they do. The state's attorney, in order to hold somebody...
They have to request it.
Yeah, they have to file a petition, quite literally, not even just request it in general, but they have to file a petition under the state statute. And it's 6.1 of 110. And unless the state's attorney files that petition, the judge cannot hold somebody without releasing them pre-trial. And that is covered by the case of People versus Gill, GIL. It was decided in December of 2019 by the appellate court. And that's why that is so important.
You're very clear that people can't be punished before they're convicted, and basically judges should make that decision with regard to getting out and such, because you're saying, look, the victim's family isn't going to be the right person to make that decision. The lawyers aren't the right person. As though the judge doesn't have bias. Judges are people, and they have bias too.
We do recognize that, but they take an oath to be fair, to be unbiased on the decision that they make. We train them. We say, no, all human beings have a chance to be biased about something. And what we say is, you put your biases aside when you make your decision. Your bias can't enter the decision-making process. And they have to take an oath to that effect. And if they can't do it, because we know some human beings can't do it, they have to recuse themselves. That's the test.
You know, recently the Ortega case, a little girl shot, and we come to learn that this is somebody out on probation. If you, in your role as the chief judge, if you're trying to say, where did this go wrong? If something went wrong, where did it go wrong? Who are you looking to?
Well, that's a fair question. Unfortunately, because of our rules of ethics, I can't comment on a pending or impending case. And this
Take it as a hypothetical.
Yeah, so this is a pending case. What I would say hypothetically is this. What we do with the young people is we don't focus on punishing them. We focus on trying to change their conduct. And you might ask, well, why? Well, because they don't have the prefrontal cortex fully developed. That's the part of the brain that makes the decision that a human makes. And that part of the brain isn't fully developed until they were 25. And so when you have a teenager, there's no way a teenager can make the right decision all the time, because they are sensation seeking. They are also very vulnerable to others in their age conduct. So we know that, and we say to them, we're going to try to rehabilitate you. We're not going to throw you away just because you've made a mistake. And we're going to stick with you to try to get you to be a contributing citizen. So we have the Restorative Justice Court that tries to give them a second chance. We try to do as much as we can to stop this conduct before it gets out of control. And yes, some would like us just to throw these kids away, but we can't do that.
You also talk a lot of, and I know this is kind of who you are, the importance of counseling and therapy and all sorts of things to get people off the streets and keep them off the streets. And I guess as I think of people who read the papers, is that the role of the judge, of the legal system, or is that the role of the politicians and the city council and others? Whose job is that?
Well, I think it has to be a part of the court system, because we were talking about young people. We know they are sensation seeking. We know that they don't think about the consequences of their actions. And so if we blindly assume that on their own they just go, oh, I shouldn't do that, and I'll stop doing it. No, we have to say, no, pal, you did this. We caught you. Here you are. And the consequences are going to be put to you. And we want you not to do that again. And so what we're going to do is we're going to test you to see if you got a mental health problem. We're going to test you to see if you have a drug problem. We're going to test you to see if we can help you by therapy, telling you, hey, what causes you to get in the car with your friends? Did you think that your friend all of a sudden had enough money to buy a Cadillac car? Or did you say, well, I didn't steal the car, so I'm going to be okay. I can get in that car with him since I didn't steal it. Don't you know that if you put a young person in a car with other young people and it's a stolen car, all of you could get charged with stealing the car? Or if you get in that car and there's a gun on the floor of that car and you're sitting in the back seat where the gun is, you could be charged with possession of that gun. So they don't consider all those consequences. That's what I'm talking about. That's what the therapy does. It says, oh, wait a minute, I didn't know that. A lot of them don't know that. And when we finally get them and we get their attention, you know, Paul, they go out and stop their friends from doing that.
Judge Evans says he'll continue working with experts in the field on more solutions the court can implement. We're going to take a quick break, and coming up next on WGN-TV Political Report, the mayor's plan to sue gang leaders stalled at City Hall. We're talking to Alderwoman Leslie Hairston. And later, a retirement and historic nomination. What's next for the United States Supreme Court? Don't go anywhere.